Yes, can cross-examine. Shield is broken. That's what we have discussed in your 1B. But they are stating here, assuming Sam's counsel does not cross-examine Ali on his previous conviction, can the prosecution cross-examine Ali on his previous conviction? What do you think? Shield is already broken. Correct? You have satisfied in section in question 1B, 54 2C satisfied. But Sam's counsel never cross-examined. Broken shield, it's open. Can the prosecution, where is it? Can the prosecution take advantage of the broken shield and cross-examine Ali on his previous conviction? That is what the question is asking you. What do you think? They have given 7 marks here, but I think your answer is not so long for your 7 marks. Okay, Paul, yes. So you're agreeing that the prosecution can cross-examine Ali on his previous conviction. That means, in another word, the prosecution can take advantage of the broken shield and can cross-examine Ali. Why? Why you came to that conclusion? Cannot. Why can, why cannot? What do you think? Because why? This is the reasoning that you have to write. If you tell can, what is the reasoning? If you tell cannot, what is the reason? Once the shield is broken in court, then the shield remains open. Okay. Therefore, anyone can cross-examine. In another word, nowhere stated in the Evidence Act under Section 54, subsection 2, only the defense counsel must cross-examine or the prosecution must cross-examine. Nowhere it is stated. Like what she stated, like what Paul have said, once the shield is broken in court, then the shield remains open. It doesn't matter who choose to take advantage of the broken shield. I'll just add people. Okay. So my answer is, since it has already been concluded in paragraph B that the exception has already been activated, okay, prosecution can cross-examine Ali on his previous conviction, as there is nothing stated in the Evidence Act 1950 as to who can cross-examine the accused. Therefore, taking into account the above, the prosecution can cross-examine Ali on his previous conviction, and pursuant to Section 120, subsection 3, the judge can limit the cross-examination. Okay, every question when you conclude they can cross-examine, you have to end with 120 subsection 3. It's something like your weight provision. You know, when you do hearsay question, most of the time you'll conclude with 73A subsection 6 or 90B or section 158. Your 120 subsection 3 is something like that. You limit cross-examination. Okay, A, B, C, D. Please take note. I will send the answer shortly in the group. Okay, I will send the answer once we have completed. I will send the answer. But you need to know how to do this question, because quite sometimes this type of character evidence never come out. I think quite some time, maybe 5-6 years, it will not come out. This kind of cross-exam, this kind of question. If you take a look at it based on the years that I've given to you all, plus there's another 1 more year. I forget to mention earlier. July 2006, question 4. Okay, July 2006, question 4 is exactly the same. Except they change your name, the name of the parties as your question. October 2013, question 5. Okay, July 2006, exactly the same with your October 2013, question 5, just that they changed the party's name. All of you have taken down the years, right? Who have not taken down the years? If you have not taken, okay, I'll repeat. October 2013, question 5 is similar to July 2006, question 4. October 2013, question 5, similar to July 2006, question 4. Okay, similar, just name only different. Then you can look at July 2008. Almost similar, I wouldn't say 100% similar, but almost similar to our July 2005 question 1. July 2008, almost similar to your July 2005 question 1. Who still, never cannot get the years? Because this is important. Where quite some time it did not come out. So that's why I'm asking you all to take note. Okay. The rest of you okay? Can? Okay, all right. You need to know how to do it. Okay. Okay, one more type of a question. If you look at a quick one. Can we do October 2013? This just question 1 only. October 2013, question 5. Character evidence also. October 2013, question 5. Just a quick one. Bashir and Jafar's question 5A. Read the question first. And maybe I give you 5 minutes. Just read the question. Just give me the answer for 5A alone. Can share the question here. October 2013, question 5. I shared in the group. Okay. So what's done? Everyone done? Okay, just the first part only. When cross-examining Helen, Helen is PW, correct? Bashir's lawyer asked her question about her previous conviction for drunken driving. Can the DPP object to such question? Okay, Mr. Paul is telling can. Why? Why can? Or why cannot? Can object, section 54, subsection 1. Section 54, subsection 1. The fact that the accused person has a bad character is irrelevant unless evidence has been given, which case it becomes relevant. Okay, 54, 1. Other than that, any other reasoning? Section 152. What is section 152? Limits. Question intended to insult or annoy. The court shall forbid any question which appears to be intended to insult, annoy. Okay, can. Okay, what other answers? Any other answer that you all have? First thing, here the fact in issue is for what? Assault, intent to outrage, modesty. Jafar is only for assault. He's going to ask with regards to drunk driving. For me, I will stop under, will put section 5 and say that the question is not relevant. Same thing. You can also, yes, Paul, Mr. Paul is correct. Not relevant. Correct? Section 5, I will stop. Finish. This is your 3 marks answer. But if you want to put like what the other students have stated, bad character is not relevant, also can, no issue. Memang bad character is not relevant. So end of the day, you see, myself, for example, I said the DPP can object to such question as it appears that those questions are not relevant to the fact in issue and therefore cannot be asked. Okay, and therefore cannot be asked. And bracket, I put section 5, Evidence Act 1950. That's it. Yes, 138 subsection 2, evidence, and the question must be relevant. You can put 138 subsection 2. Okay. Some of you went on other class, they went on to 146C, 148, 149. Okay, for me, you want to add on to it also can. You don't want to add on to it also can. Myself, I see 3 marks, question not relevant, move on. You see, sometimes if you know how to use the provision, you use, okay, fine. If you don't know how to use the provision and you use it wrongly, instead of getting 2/3, you will get 0/3. This is the problem. Okay. If you know, you use. You don't know it. In fact, my answer, I have 146 sub C, 149, 148. But I don't want to give because not everyone will know. Safe side, section 5, not relevant, move on. You'll be doing relevancy question now. You will see how to answer. You can repeat. You see, relevancy question, you can use anything from 5 to 14 or 5 to 15. Actually, it's 5 to 55, but most of the time, we will be using 5 to 15. You can use anything. You don't have to follow my relevancy provision. As long directly your answer is with regards to your fact in issue, you keluar tajuk, no issue, can admit. Okay, please take note, your character evidence question, this type of question. Not relevant, not relevant. Civil, you need to take note E and F. Okay, for civil case, E and F. The next part is your relevancy part. This is your question, January. What year is it, the relevancy question? July 2005, question 2. Correct? Am I right? July 2005, question 2. Discuss the relevancy and admissibility of the following fact in issue in A, B, and C. Right? Look at the answer first.
Now, like I said, I think sometimes maybe the first part is enough, but I don't know what exactly.
Rambo is charged with rape of a 9-year-old girl who he claims consented to sexual intercourse with him. Can the girl's alleged consent to sexual intercourse be admitted as evidence? Look at the age. Okay, so PP versus Rambo, a charge for rape, correct? For a 9-year-old girl. And also his defense is consent. She consented for the sexual intercourse. Now, they're asking you, can the girl's alleged consent to sexual intercourse be admitted as evidence? 4 marks. Can, cannot? Cannot. Why cannot? So that means you're telling consent cannot be accepted, correct? Because this is statutory rape. Correct? This is a case of statutory rape. Consent is irrelevant. Section 5. Your case of Syed Abu Tahir, anak lelaki Muhammad Ismail. Who, correct, 9 years old, cannot give consent, statutory rape. Who don't have the case? Syed Abu Tahir, anak lelaki Muhammad Ismail. Okay, S-Y-E-D, space A-B-U, space T-A-H-I-R, anak lelaki A-L, A-L, Muhammad M-O-H-D, space E-S-M-A-I-L. E-S, it's not I, E-S-M-A-I-L. Syed Abu Tahir, anak lelaki Muhammad Ismail, E-S-M-A-I-L. Okay, so can the girl's alleged consent to sexual intercourse be admitted as evidence? So how you can answer is that the girl's alleged consent is irrelevant as the effect in issue here is for statutory rape. Under Section 5, consent is irrelevant and can be seen in the case of Syed Abu Tahir. Something along that line. Answer the question. That's it. Okay? Can? Okay, second one. Daisy, a university student, was injured in a road accident while being driven by her wealthy boyfriend, Nick, who was intoxicated at the material time and who slammed the car into a huge tree on the campus. In a civil action for damages by Daisy against Nick and his father, the owner of the car, can, pointer 1, the evidence of Daisy pre-accident beauty be given? Pointer 2, Daisy tried to prove that Nick's father is very wealthy. Okay, first, identify the parties. Second, first identify the suit. Second, identify the parties. So who is suing who? In a civil action for damages by Daisy against Nick, D versus N, correct? Negligent driving, suit for damages. Okay. The evidence of Daisy's pre-accident beauty. Relevant, irrelevant. Is her pre-accident beauty relevant? Please take note, the suit here is for damages. Relevant, not relevant. If relevant, which provision? If it's not relevant, no issue lah. We fall back under our section 5, not relevant. So which provision if you think? Yes, relevant, not relevant. Anyone? Okay, someone answered. Relevant, Tan, relevant, iPhone, section 12, Muham, section 12, Janani, section 12. Okay, section 12 for to increase the amount as to damages. Why you want to lead that type of evidence? Because I want to give evidence to increase my amount of damages. Before accident, I was like this. Now after accident, my situation is like this. So that is why your section 12 will come in. So you can say relevant, my answer, later I'll send it to your section 12 to increase the amount of damages, the first part. Only one provision only. I got no case, nothing. If you have a case for section 12 on the issue of increasing the amount of damages, you can put it. Okay. Part 2, Daisy tried to prove that Nick's father is very wealthy. Relevant, not relevant. In this suit for negligence, she wants to show that Nick's father is very wealthy. Is this piece of evidence will make any difference to the claim of damages? That's how you have to see whether it can be admitted or cannot be admitted. Okay, not relevant. Why? Not relevant. All of you are telling not relevant. Why? Why not relevant? The fact that he's very wealthy, isn't it, can be used to increase your amount of damages once again? Dr. laughing already. Why? Because end of the day, it doesn't matter. Poor people bang you or someone who's rich bang you still have to pay the same judgment sum. You need to understand the reasoning behind it. You still have to pay the same judgment sum, the same thing. So that is why it is not relevant. Section 5, once again. So same thing. You can see this type of question, also repeat question. I'll give you the year as to which question it repeated. Once again, section 5, not relevant. You can see our question 2A also we discussed section 5 because that is the answer. The moment you think it is not relevant, don't hesitate to put, oh, 2 times I must put section 5. I cannot be like the examiner is trying to trick me. No, actually you all are making a mistake, So if you think that correct, go ahead. Go ahead. You're confident, go ahead with your answer. Correct. The court awarding damages sum should not be punitive. Yes. I mean, your reasoning is correct, should not be punitive, but whatever judgment sum that has been awarded, doesn't matter whether you're rich or poor. If your case has been established, you have to pay. Dissatisfied, appeal. Okay. Second part. Dr. Malai is sued for damages for medical negligence by the administrator of the estate of Dipti, a high society lady who died while undergoing treatment to enhance her looks. Can the plaintiff's lawyer adduce evidence that, number 1, Dipti was a highly respected member of society who had several titles and that her death is a loss to many charities in which she held high office? So now, estate of Dipti versus Dr. Malai. The suit here is for medical negligence, correct? Now the plaintiff's lawyer, okay, for Dipti's estate, they want to adduce this evidence. So is this evidence relevant or not relevant? Pointer 1. Dipti is someone who's highly respected in the society. Relevant, not relevant? Irrelevant, right? Irrelevant to the fact and issue of medical negligence. Section 5, move on. So you can see this here, so many section 5. So what student will do? Cannot be. Simply put, 1 section, gone. Instead of getting 3 marks, 0/3. Can you see what is the issue here? Okay, so please take note. Now here you all can answer. That means you are confident this is the answer. So make sure during the exam also, it should be the same thing. Okay, the drugs administered by Dr. Malai had expired shelf life. Relevant, not relevant? Relevant, which section? Relevant, okay. Relevant, section 7. Someone said section 7 to show cause or effect. Some more? Section 9 to show what? Section 7, 1 person answered to show cause or effect. One more said section 9. Section 9 to show what? Section 9, if you know, got 5 parts to section 9, correct? 1 identification, 1 support, 1 rebut, 1 explain. So which part of section 9 you all are relying? Section 7, which part? Okay, section 9 to support an inference. Okay, can. Others? Section 7 to show what? Cause or effect. Can you use opportunity? Illustration C. Illustration C, opportunity. The drugs administered by Dr. Malai had expired shelf life. It shows that opportunity for him to have, he have given that drugs. That is why she has passed away. Cause can. Okay. Question 3. Okay, this one. 2 days earlier, another patient had died in Dr. Malai's clinic. Relevant? Not relevant. Pointer 3. 2 days earlier, another patient had died in Dr. Malai's clinic. Relevant? Not relevant. Relevant. Relevant under which provision? Okay, section 9, I understand why. Okay, section 9, why you're putting section 9? To support. Section 15, to do what? Similar occurrence. So you want to rebut accidental, correct? You want to rebut accidental. So that is why you want to show similar occurrence. See if the act is accidental or intentional. Section 6. Okay, section 6, how? Section 6, how are you going to use section 6? One transaction, are you going to use that? One transaction, I don't know whether can fit in here or not. Okay, the rest of it, I think okay, but one transaction, I'm not sure whether can fit in here or not. No reply, okay. Question 5. Dr. Malai was carrying an adulterous relationship with his nurse. Relevant? Not relevant. He is sued for medical negligence for damages. Okay. Now he's carrying the fact they want to adduce this part. Dr. Malai was carrying on an adulterous relationship with his nurse. Not relevant. Okay. Not relevant. Okay. Civil case, not relevant. Clear cut, huh? And your last one, a week earlier, Dipti had taken out a large insurance policy which was payable to Good Looks Foundation, which gave grants to Dr. Malai for research. Relevant? Not relevant? Relevant, section 8 to show motive. Why section 12? Huh? Someone put section 12. I think section 8 lah, relevant motive. Okay, please flip to, if you can, I don't know whether you all have this here or not with you. January 2002, question 8. Got none? January 2002, question 8. Don't have this question. Okay. Can you all see? Okay. If you look at that question, same. R is on a charge of rape of a 10-year-old girl. He wants to prove that she consented to the sexual intercourse with him. Same answer. Can the girl's alleged consent to sexual intercourse be admitted as evidence? I put the question in the group ready. 2241 Isaac Lim. Put the question in the group ready. Same answer, agree? Okay, the second part, a teenage girl, T, was injured in an accident with a motor car driven by N. As a result of the accident, T has a long and unsightly scar running down her left cheek. Little bit of difference, okay? In a civil action for negligence by T against N, here they remove the word of damages. That question, they gave you civil action for negligence for damages. Here they remove. Against N, can number 1, evidence of T's pre-accident duty be given? Our answer was now, can section 12 to increase amount. T's attempt to prove N is very wealthy, cannot. Same answer. Okay, sub C, they change a bit for you, a bit. But pointer 1, pointer 2, pointer 3, pointer 4, pointer 5, almost similar answer. I'll show you where's the difference. Here, M is on a charge of murdering D, his wife, by poisoning her with arsenic in a high-rise apartment where they live. The prosecution wants to adduce as evidence that, so here PP versus M, this is D, okay? Charge is for murder by poisoning her. Same thing, question 1, D was a highly respected member of society. Not relevant, no issue here. Charge here, murder, not relevant. Sub 2, M purchased arsenic from a chemist. This is the different part. M purchased arsenic from a chemist. Can fall under which section? What do you think? Which section? Section 8, preparation, opportunity. Okay. Third part, M told the chemist that he needed it to kill the weeds in his garden. Relevant? If relevant, which provision? I'm buying this poison. You know it's a poison. You're buying it from the chemist, and you are telling the chemist, why I'm using this because I want to kill the weeds in the garden. That is your reasoning. You don't have to tell, correct? You don't. So what you're trying to do? Under which provision it will fit? Or you think it's not relevant? Section 11 to show what? Section 11 to show what? Facts not otherwise relevant becomes relevant. Why you think here facts not, why you think this fact is not relevant? Section 8, illustration C. Sorry, illustration E. Section 8, illustration E. Yo Hok Cheng, your case of Chandra Segren, creating an appearance which is favorable to an accused. Okay, this is the different part. This is some, okay, this one, section 8, illustration E, you need to take note. Okay, not only for this question, but just look at it. Section 8, illustration E, these two cases. Yo Hok Cheng, who don't have it? Okay, Yo, Y-E-O, Hok, H-O-C-K, Cheng, Yo Hok Cheng. And also the case of Chandra Sekara, C-H-A-N-D, C-H-A-N-D, R-A-S-E-K-A-R-A. under section 8, illustration E. You need to take note. Please take note of this provision. Quite some time it never come out. Okay, so this is the part which is different from your earlier one. Your fourth one, M was carrying on an affair with his secretary. Same, correct? Same for your earlier one. But for this part, on your charge of murder, is this piece of evidence relevant? There we have answered not relevant. Here, is it relevant? The fact that he was carrying on an affair with his secretary, is it relevant? Relevant under section 8 to show motive. So if you want, you can use your cases. I use Lim Kong, Wong Fo Chin. Okay, all the cases is in your book. Okay, is in your book. Because for me, right, I may have different case, you will have different cases. As long our provision is the same, I'm okay. D had taken out a large insurance policy a month earlier, which was payable to M. Same like your earlier one. So here, section 8, Sunny Ang, to show motive of the killing. Same answer, right? 4 and 5, section 8. But that's the answer. What to do? So you don't think that, oh, one is section 8. That means one more cannot be like section 8. It should be a different provision. Cannot, huh? So you can see 2 questions I've showed you already. Similar, almost similar, same thing, repetitive. So if you can do your past year, there's no chance you will fail because questions are repetitive. So take note, this kind of question never come out. Now your relevancy question, it became like one whole paragraph, 25 marks. So from there, you identify. If you can look at it, 2018, 2019, 2021, same kind of a question. This kind of question never come up. So if come up, please do. This is a bit straightforward. Please do this kind of question. Okay, all right. Okay. I think I made a mistake. Actually, I want you all to prepare another question, but I told you all to prepare another. It's not October 2000. I asked you to prepare October 2005, correct? Right? October 2000. Actually, it's supposed to be July 2007, question 2. Can we do it together? Because I think this question, part 2, is a bit important, which I want to address. July 2007, question 2. Can we do it together? If you don't have this one, someone have to send because my one got answer. Or I just erase the answer. You have it, Logan, clean copy.
Someone has posted it in the group.
Or someone posted in the group. Our group or this group?
This group. I'll post it.
None. July 2007. Question 2. A is charged. Yeah, someone else. July 2000. Okay, question 2. Okay. A is charged in the High Court at Alosta under Section 302 of the Penal Code for the murder of his lover, B, on 15 January 2003 at about 2 a.m. at the address Kedah. A pleaded not guilty and the case was accordingly fixed for hearing. Okay, take note, PP versus A, charge murder of B. Date 15 January 2003. Put all these points clearly so that you won't make a mistake. Okay, clear on these points, no issue. Now you are to discuss the admissibility of the following pieces of evidence which the prosecution intends to adduce at the trial. Okay, Romans 1, an entry in B's diary on 14 January 2003 stating, I can't go on like this any longer. I must tell A that I don't love him anymore. Now the prosecution wants to adduce this diary, correct? How? I give you all a bit of time to think. Think properly, whether it's hearsay, what is the purpose, am I adducing it, or not hearsay. If not hearsay, why I want to admit. Okay, first you need to see whether hearsay, general rule, if it's hearsay, I want to establish to prove the truth of the statement, or I want to prove to establish by evidence not the truth of the statement, but the fact that it was made. When you have only two options. One, if it's hearsay, I want to prove the truth of the statement. Definitely hearsay, I cannot admit. I must see whether any exception is applicable. Correct? Second thing, no, I don't want to. What's the purpose? I want to adduce this thing, not to prove the truth of the statement, but the fact it was made in order to show what? For example, a state of mind, to show motive, to show relationship, to show other things. So you have, before we can go into one or two, you all have to tell me the answer. What you think? Hearsay, not hearsay? Hearsay, okay. C is telling hearsay. So if you're telling it's hearsay, you're telling I want to prove, the prosecution wants to prove that she don't love him anymore, correct? I must tell A that I don't love him anymore. I want to go on. I can't go on like this. The reason being, for my question to y'all, what is the purpose of the prosecution proving she loves him or she don't love him anymore? What is the purpose? You want to adduce this thing to show what? Because if you're just going to admit like this, what's the point? What's the purpose to establish the truth? You want to establish the truth, or you want to admit this entire thing under your relevancy provision? Okay, you will 32(1)(a) will not be applicable here, either under dying declaration or your cause of transaction, also a bit tough to admit if you look at your cases. 1A out of 32(1)(a) under dying declaration, definitely cannot. But the other part of it, cause of the same transaction, a bit difficult because you may fall under your too remote category, you will not be able to establish it. Okay, so all of y'all are taking the stand it is hearsay. Who is taking the stand? It is not hearsay. I mean, it is hearsay, but the purpose that I'm going to, the purpose I'm tendering this statement, I can't go on like this anymore. I must tell A, I don't love him. It's not to establish the truth, but to prove the fact that it was made. That means if I'm going to prove that fact, I'm going to show what? I'm going to go under my relevancy provision to show motive of killing, to show the relationship of the parties under section 9. I'm going to show the state of mind of the lady, what's the name, of B at that point of time. Correct? To prove the fact it was made. This is one of the type of a question which is a bit funny one, you know. When you look at it, it looks like hearsay, but actually when you go extra one step, it is not hearsay. Okay? I just read out my answer to you. It's a quick one. Okay. General rule, hearsay. Hearsay can be in the, I just explaining, you don't have to write. Hearsay can be in the form of document, PP versus Azila bin Hadri. Why, if prosecution wants to adduce the diary to prove the truth of the content by B, then it is hearsay. Okay. However, this will not be applicable here. Okay. As the purpose to tender the diary is to establish by evidence not the truth of the statement, but the fact that it was made, i.e., in order to show section 14, state of mind. Okay, illustration A, i.e., at the time she made the statement, she wanted to tell A that she does not love him anymore. The relationship of the parties under section 9 to show that both of them are not in good terms, and section 8, motive. Due to their relationship status, this could be A's motive to kill B. So I want to admit, or I want to admit this entire thing, not to prove whether you love him or you don't love him, but to show 9, 14, and 8. This is the purpose. So I won't take it as hearsay. So next part is, this is your relevancy. Next part is your mode of proof. How I want to tender, I must give the entire diary. Primary evidence, the diary itself ought to be tendered in court under section 62 and 64. Okay, let's say you don't talk about your mode of proof, can or cannot. Okay, for me, can. But I know some answer have stated that cannot, you have to add on your mode of proof. This is up to you. If you look at the question, discuss admissibility. You have discussed admissibility. If you don't know mode of proof, if you are weak in your documentary evidence chapter, you cannot do much. Now 20 days only. Okay, cannot, don't worry. Just answer on your relevancy. They will give you your marks. I have to give you a full answer. Okay. My answer, I have put, there was a really good analysis of hearsay. My answer, I have put in mode of proof. I have put, because I'm giving you all like not a complete answer. I wouldn't say a complete answer. I'm giving you what is based. Okay, what this question is based in this way. This is how you have to answer. But I know at this point of time, even my own students, a bit difficult to get on the issue of documentary evidence. Which one to provide? Which one to actually? To be honest, it's very easy. Don't ignore the new cases, ignore whatever cases recently that has been given. Just use your evidence act and see primary, secondary. You know what amounts to primary evidence. If cannot fit in your primary evidence, go to your secondary evidence. Of course, you have to account to where is your primary evidence. In this question, you don't have to go that far. No need. Because they already tell you diary. Just adduce as primary evidence. Don't overthink. Oh, where's the diary? Maybe the diary not. No need, no need. That one all you are inferring on the facts. No need. Diary is here. I adduce in court. Finish. You get your 5 marks. That's it. Even you put on admissibility, you don't put on your what they call your mode of proof or what. I don't think they're going to deduct any mark. You will get at least 4 of 4. Not too bad, what? You already answered the question already. So don't be so, this one, I must answer everything. Okay? Because I'm aware, I'm truly aware there's a new case on it. I've gone through I went through with my students, but my personal view, please ignore at this point of time. You cannot absorb everything. Just focus on whatever that you all have. Ignore your new cases temporarily, although you think there's any change or what. Okay? Next, that R was told by K, B's cousin, a month before B's murder, that B hated A and was going to break up with A. K, however, has left the country and is untraceable. Okay, once again, R was told by K. Who is R? Oh, sorry, R was told by K. Who is K? B's cousin. So B told K, K told R. Correct? B told K, K told R. A month before B's murder, that B hated A and was going to break up with A. Now, K, however, has left the country and is untraceable. Okay. Now they want to admit, can the question here is asking you, can the prosecution, okay, use R to admit this statement that B hated A and was going to break up with K? Please look at the facts properly. Huh? B told K, K told R. B told K, K told R. Second-hand hearsay, multiple hearsay. Okay, second-hand hearsay, multiple hearsay. So what is the issue here? Second-hand hearsay, multiple hearsay. What is the issue? Can be admitted, cannot be admitted. Cannot adduce because it is multiple hearsay. I also don't know why 9 marks. That's all your answer. Okay. I also have another answer where they have given section 50. You see, why I don't want to give this answer, because they are in that answer, how it is stated, assuming the parties, section 50 is on opinion as to relationship. Okay. The first answer there, you already put the word assuming this is from the knowledge of the parties. Then section 50 is relevant. Okay. I don't want to use that answer. I don't want to give section 50 because you are assuming nothing stated on the facts. We don't assume. If the question states, you all have identified multiple hearsay cannot be admitted. Stick to your answer. What can we do if they give 9 marks? Just that's all. That's all your answer. Okay, of course, you have to explain first what is hearsay, your general rules, Subramaniam, and all. Then you say, looking at the facts, it appears that this amounts to a multiple hearsay, which remains inadmissible. Hence, cannot be admitted in evidence. That's it. Don't go and elaborate further just because it is 9 marks. Another answer, they said, assuming if it's with regards to opinion, then section 50 is relevant. They use a case, then you give another answer. This is multiple hearsay. Although you may be right, but the facts here do not suggest as to the relationship or whatsoever. Section 50, if you look at, is with regards to relationship. Here, nothing to suggest with regards to relationship. So no need to put just full stop, multiple, all your answers are correct already. Just follow your answer, be confident with your answer. Okay? Sub C, a statement made by B to the ambulance attendant while being rushed to the hospital stating, A did this to me. B died in the ambulance before reaching the hospital. Can this piece of evidence be admitted? A did this to me and B died in the ambulance before reaching the hospital. So who is coming to court to admit this statement? Should be the ambulance attendant, correct? Because the statement is given to him. Of course, they never tell this clearly, lah. Okay, nothing clearly, but definitely it should be the ambulance attendant. So he's coming to court to tell that B told me this statement. A did this to me. While I was rushing her to the hospital. Can you admit? Cannot admit. How are you going to start? This is 10 marks. 32(1)A dying declaration. Okay. You see, I just want to explain. It's right. You have to start off with Subramaniam, tended for the truth, exception 32(1)A. One thing you must understand, 32(1)A dying declaration, 32(1)A got 2 parts to it. I don't know whether you all know or not, but if you just open to 32(1)A for the benefit of the rest who don't know, 32(1)A. First part of it, when the statement is made by a person as to the cause of his death, that is what your dying declaration. Or as to any circumstances of transaction which resulted in his death. This is wider than your dying declaration. Okay, this is your circumstances which resulted into his death. So normally when you use 32(1)A, my personal view, please be a bit more specific. Just to tell the examiner, you know 32(1)A is not your common law dying declaration. Okay, your 32(1)A is a wider provision compared to your common law. This is clear-cut case, correct? A did this to me, dying declaration. Because B died in the ambulance before reaching the hospital. So you go under your dying declaration. But of course, you cannot stop your answer just with 32(1)A. you have to go on whether the statement is too remote. Your case of, what case you need to, what case? Whether statement is too remote. First, the 32.1 SIM2B must be satisfied. Your precondition in section 32.1 must be satisfied. Here, it is not an issue to satisfy your 32.1 because she's already dead. Then, after that, you go into 32, then you go into whether the statement is too remote. Normally, there are few cases for statement is too remote. I will use Pakala Narayana Swami versus King Emperor, or you can use Yo Hok Ching or other cases that you want, that you have stated. So I put on the facts, the statement was made to the ambulance attendant while being rushed to the hospital. Hence, it can be argued that the statement that was made by B was not too remote. Then your actual words spoken by the accused, by the deceased. Ong Hok Cheng versus R. Then you try to see how you should argue. Because it is in inverted comma, most likely this is the actual words. A did this to me. Then subject to the weight provision. So you have to say it can be admitted under 32.1a, dying declaration. If the first part, the statement with regards to his cause of death, but subjected to section 158, PP versus Muhammad Jamil Yahaya as to the weight of the statement. Why? Because the maker cannot be cross-examined. A little bit more longer because this is 10 marks. Okay. Whether must put in so much of cases, have to lah. At least, maybe I would have given 4 cases. From here, SIM2B, Yo Hok Cheng, Pakala Narayana Swami, Muhammad Jamil Yahaya, Ong Hok Cheng, correct? I gave you 5 cases. Muhammad Jamil Yahaya, it's good if you can remember because section 158 is applicable for most of your hearsay. Like under your 32.1a to j, if you want to admit, you can use section 158 and you can use the cases. If statement is too remote, you don't want to remember all the cases I've given, you can remember 1 case, Pakala Narayana Swami. If you don't want, go to Yo Hok Cheng. If you don't want that one also, Buddha Sting. 1 case is fine. Then SIM2B you need to know. Because SIM2B is your general one for your precondition under your 32 subsection 1. Okay. Alternatively, I got another answer, section 6, res geste. Anyone agreeable for section 6, res geste here? Or you thought about section 6, res geste? Because if myself, I won't consider section 6, res geste. Why? Because clear cut, this is the dying declaration, your first part. So that is why I don't want to consider. I know some books that given you section 6, res geste. I don't want, because by the time I write and finish for my too remote, actual words spoken, maker cannot, appropriate weight should be given, maker cannot, because due to the fact that maker cannot be cross-examined, I think your time is enough instead of you going to section 6. You get me? So that is why I don't want to use sections. But if you think you have the time, you want to explain for section 6, can, but please make sure you use it properly. Myself, I won't use it. Why can subject to section 158? Okay, section 158 is your weight provision. Even though, okay, for example, your hearsay, this is an exception to your hearsay rule, correct? You can admit, but it's an exception. So this kind of evidence, although can be admitted, the weight that is attached to it is lesser. It's not the best evidence, correct? Because it's an exception to the hearsay rule. Since it's an exception to the hearsay rule and the weight that is attached should be much lesser. Why? Because the maker cannot be cross-examined. That is one of the reasons that is given in Muhammad Jamil Yahaya. Or you can see another case of Tukiman. I'm not sure whether you all have all that cases. Why I don't want to mention so much of cases now. I don't want you all to be stressed. Now 5 cases or so, you feel a bit this one ready. So if you don't want to use all my Tukiman, whatever case, just use Muhammad Jamil Yahaya. Very simple. 158, Muhammad Jamil Yahaya. Very simple. You don't have to remember the rest of it. Can live. Okay, I see got any other case under 30. 32.1a must know. 32.1a you cannot let go because it's highly examinable. 32.1a, Muhammad Jamil Yahaya is the best lah. The rest of the cases even more confusing. You see, the book that I have, actual words spoken by the accused, they have given a lot of cases. Chan Kwat Pul, Nembat, Narajan, Ong He Hock, To Lai Heng. I ask you to remember one. Okay, only one on her house and move on. Move on to your weight provision. Okay. Okay. I cannot do the other question because I don't have and I didn't prepare. I thought it's July 2007. I try to send the answer in the group by next week or what for the next question. The one that you all have prepared. What year was it? July 2000. Oh, sorry, October 2005, correct? October 2005, question 3. Am I right? You all have prepared, correct? I try to send the answer for this thing. Okay, one more year, I just want you to take note. Is your October 2005, question 5. Do you all have that question? October 2005, question 5. I don't have the time to do it with you all, but I just want to inform you all. If I can do another class before the exam, I may want to do this question. October 2005, question 5. Who don't have it, I will send in the group. Who don't have it, okay. The answers I've sent to the group. This question. Okay, please take note. Please take note of October 2005, question 5. Just a quick one. Question 1 is asking you on the legal burden of proof in James' trial. What is the overall standard of proof? This is a question on your burden. The issue here is he was diagnosed with suffering from schizophrenia, mental disease and all. So who has the burden of proof to prove the charge of murder? Take note. Please take note, part A is for the prosecution. Don't write your answer wrongly. Please, just because it is 10 marks, please don't write your answer wrongly. Who has the overall legal burden of proof in James' trial? They already give you a hint ready. Overall legal burden of proof in James' trial. They are talking to you only on the prosecution burden and standard of proof. Okay, second part, who has the legal burden of proof to prove the defense of unsoundness of mind in James' trial, and what is the standard of proof of such defense? This is where you have to go into your 105. So normally how I will do 105, 101, 102, 103 read together with section 105, the case of Nagapan, Upusami versus PP. Then I go through my law on insanity. Then I will say how the burden shifts on James. If you go and put in your question A, that James bears the legal burden of proof, blah, blah, blah. I mean, to prove this thing, gone. A already give you the answer as prosecution. The answer is only for prosecution. You cannot put B's answer in A. Okay? Please take note A, and very important. This one, why I'm telling you all, you can see, never come on for quite some time. So please take note this kind of question. 105, 106, take note. Question C is the opinion of a psychiatric in respect of James' state of mind at the time of killing Jimmy admissible as evidence in James' trial? What they're asking you? This question is about what? is the opinion of a psychiatric in respect of James' state of mind. Opinion, evidence, section 45. But what is the issue in this case is that there is two cases they want you to discuss. Okay, what are the cases? Let me tell you the case. I'm sure it's in your book, but I will just give it to you. The case is R versus Turner, T-U-R, and yes, someone have stated Turner and Laurie's case. Why? One part, they have concluded that this psychiatric issue is something where everyone can decide. Everyone can decide. You don't have to go through your rules on opinion evidence. That means you don't have to prove professional whether he's skilled by professional study or so on and so forth. The other case telling you, no, this is something which only the expert can decide. That is what they want you to discuss. So you have to put in the two cases which she has mentioned, Laurie and Turner. It's definitely in your book. That's all you have to do. That's why 5 marks. Okay? Is the opinion of a psychiatric in respect of James' state of mind at the time of killing Jimmy admissible as evidence? After you have put that two cases, you take a stand whether you need an expert to assist you to see whether someone got this disease or not. So you choose whether Laurie or Turner. You have to put a conclusion. This question is for 105. If you open another one more under 106, a quick one, you can do it by yourself. I'm just letting you know quick. Question 7, July 2013, question 7. July 2013, question 7. Got? July 2013, question 7. The question starts with world next. Got, right? Okay. This one is on your 106. Your A is straightforward. What is the standard of proof? This is civil case. Miller versus Ministry of Pension, balance of probability. Your B is where you have to use who has the burden to prove that later you all read, I just give you the answer. Who has the burden to prove that the board of directors had or had not approved the investment in $1? This is your section 103, 106. The burden is on Shahul. Later you will read the question. Sharul has to prove because he only has the knowledge. You can use your case of Ettigal versus R or any Mary Ng versus R, Crown. Up to your whichever case you want to use, that's your wish. Okay, this is just my thing. And sub C, against which party would adverse inference apply for not producing the minutes of board director meeting? So who bears the legal burden of proof? If you don't adduce, the party who bears the legal burden of proof and who don't adduce, then adverse inference can be invoked against that party, which is Sharul in this question. Okay, so you need to take note for your exam 105, 106, 103. Quite important. Okay, and your case of Shimbagawali. I don't know whether some of you were there in my earlier class or not, but you need to take note of Shimbagawali's case. You need to take note on the issue of burden with regards to Shimbagawali's case when it comes to fraud and forgery. I've been repeating this for quite some time. The second part is your law governing signature, where Young Arif Married Peter has given 5 or 6 steps, okay, as to how you can determine whether it's fraud or forgery. I think paragraph 45 of the judgment, you can look at 1, 2, 3, 4, 5 steps. You need to know, have to know that one. Came out in your July 2019 actually. Okay, all right. The other answer, I'll give it to you all. I will try to prepare